Good day, ma'am. I am Daisy Siratonal, fourth year base criminology, and today I'm going to summarize the midterm coverage for the subject Clj-5 Evidence. Judicial notice coming from the maxim of what need not to be proved, meaning that the court widely accepts facts that do not need evidence because it already known to them. So the purpose of the judicial notice is in order for their conveniency to save time and effort. When is the judicial notice mandatory? The court shall take judicial notice even without the introduction of the evidence if it is covers laws, geography, official acts, and histories. When judicial notice is discretionary. So, the court may take judicial notice discretionary as to matters of public knowledge, capable of unquestionable demonstration, ought to be known to the judges as to their judicial function. When we say public knowledge, it refers to the common and general knowledge. So it refers to the information that is widely known, easily accessible, and generally accepted by the public. So next is the capable of unquestionable demonstration. It refers to the facts or evidence that is that can be shown to be undoubtedly truth or factual. Ought to be known to judges of their judicial functions, meaning it refers to the facts that judges are aware of because of their judicial rule. So, what is the difference between the judicial notice and the judicial knowledge? So, when we say judicial notice, it is common or it is already known that do not need to have or to present facts in order to prove. However, in judicial knowledge, it is the knowledge of a judge in a court proceeding. So, what is the difference between admission and confession? So, when we say admission, it refers to a statement of one's interests that do not constitute or that doesn't have the acknowledgement of guilt. However, in confession, it is a statement of or the direct acknowledgement of guilt in a criminal case. So, judicial admission, it refers to the party's statement that doesn't require further proof or the a statement of a party in a court proceeding that doesn't require or doesn't need to further proof. So next is the res inter alius acta alteri nocere non debit, which means things done between strangers ought not to injure those who are not parties to them. The meaning of this maxim is that this principle means that agreements, contracts, or dealings between two parties cannot be used to the disadvantage of or impose obligations on a third party who was not involved in the transaction. So, there are two branches of res inter alius acta rule, the admission by third party and similar acts as evidence. So, general rule to the admission by third party, a person's right cannot be affected by others' declarations. As to the exemptions to the rules, the admission by partners, agents, conspirators, or privies. And the second branch is the similar acts as evidence, which stated that past actions cannot prove future conduct. So exemption to the rule, it can establish intent, identity, or system. So next is the implied admission. So when we say implied admission, it refers to the situations where a person's conduct, silence, or failure to respond is interpreted as an acknowledgement of fact. So there are types or three kinds of implied admission, which is the implied admissions by silence, admissions by flight, and admissions by compromise. So when we say admissions by silence, it refers to the failure of the accused to deny an accusation may imply guilt. So meaning pag nagiging tahimik or hindi nagsasalita ang isang party or isang accused is masasabi na ito ang accusation sa kanya is totoo, but take note na dapat hindi naaapakan ang rights ng isang tao o isang accused na which is the right to remain silent. So, admission by flight, it refers from running from justice, suggest guilt. Next is the by compromise, meaning offering a settlement in criminal cases may indicate guilt. So, meaning pag binayaran mo yung isang tao as a settlement, it is a acknowledgement of guilt, o meaning nagkakasala ka talaga. What is extrajudicial confession? So, when we say extrajudicial confession, it is a confession made outside the court, or it cannot sustain a conviction unless corroborated by evidence of corpus delicti. So, ang extrajudicial confession is, an example of this is the custodial investigation. So, it cannot sustain a conviction unless hindi siya nagagamitan or walang corroborated evidence of corpus delicti. So, pag sinabi natin corpus delicti, it is the body of crime. Not literally na yung body talaga. It refers to the actual commission of a crime. So, generally, there are three general forms of evidence, which is the object evidence, documentary evidence, and the testimonial evidence. So, first, let me introduce to you the object evidence. So, when we say object evidence, it refers to the physical items that are presented in court as a proof of facts in issue. So, these objects are directly perceived by the senses of the court, which is the seen, touch, hear, examine, and serve as a material proof in a legal proceeding. So, the evidence, the requisite for the object evidence, that the evidence must be relevant, competent, authenticated, and formally offered. So, there are three categories of object evidence for authentication purposes. First is the unique object, object made unique, and non-unique object. So, when we say unique object, it refers to the items that have distinctive features, making them easily identifiable. So, the object made unique, it refers to the ordinary objects that have been marked or altered to make them undefinable. Then, the non-unique object, it refers to the items that lack individual identifying marks and cannot be distinguished on their own. This is the documentary evidence. So, when we say document, it refers to any material that contains written, printed, recorded, or digital information that can be used as evidence or reference in legal, business, or official matters. So, generally, there are two kinds of documents, which is the public and private document. So, when we say private, when we say public documents, public documents are those that hold official status and are recognized as authentic and legally binding without the need for further proof unless their authenticity is questioned. So, examples of public documents are those official acts or records of sovereign authority, official bodies, tribunals, and public officers. Next is the documents acknowledged before a notary, public records of private documents required by law to be recorded, treaties and conventions between the Philippines and foreign countries, and all other documents are known to be private. So, public documents as evidence means that public records created by public officials in the course of their duties may serve as a prima facie evidence of, when we say prima facie evidence, it can stand alone. So, meaning, prima facie evidence of the facts they contain, meaning that this means that they are presumed accurate and valid unless proven otherwise. So other public documents are also admissible as evidence even against third parties to establish both the occurrence of the event that lead to their creation and the date of execution. Next is the original document rule, or what we call the best evidence rule. So the original document rule states that when the content of a document is at issue in a legal case, the original document must be presented as evidence. So, the original document is the best evidence and must be submitted when its terms are disputed or under scrutiny. But exemption to the rules, dito na lalabas or dito na magagamit or magiging allowed si secondary evidence when the original document is lost, destroyed, or unavailable without bad faith. If the original is in the possession of the opposing party and they refuse to produce it, so meaning yung document is nasa kabilang party tapos hindi nila binibigay, pwedeng magamit yung secondary evidence. And next is when the document is a public record and a certified copy is sufficient. So what is parole evidence rule? So the parole evidence rule states that when the parties have put their agreement into written contract, any oral or extrinsic evidence that contradicts, varies, or modifies the terms of the written contract is generally not allowed in court. Next is the testimonial evidence. So, pag sinabi nating testimonial evidence, it refers to the oral or written statement given by a witness under oath on a legal proceeding. So, ang ebidensya ito ay it refers to the personal knowledge, observation, and experience of a relevant facts or sa isang mahalagang pangyayari. Sino ba si witness? So, si witness is, it provides testimony under oath in a legal proceeding na may kakayahan siyang mag-perceive or mag-communicate ng information or based on his or her personal knowledge. So, what are the qualifications of a witness? First is, all person who can perceive and perceiving. So, meaning, ang isang tao is may kakayahan siyang maipahiwatig or makaunawa ng isang pangyayari. Meaning, kaya niyang sabihin kung ano man ang kanyang nakita, naobserbahan, or yun nga, kung kanyang naobserbahan sa kanyang nakita. And next is can make their perception to others may be witnesses. So, meaning, kaya niyang ipahiwatig sa iba ang kanyang nakita o kanyang na-obserbahan. Next is the qualification of a child witnesses. So, kagaya nga yung sinabi ko kanina, the qualification of a witnesses includes all persons. So, meaning, kasama dito yung bata. So, ang isang bata, magiging qualified lang siya bilang isang witness kapag he must have the capacity of observation, recollection, and capacity of communication. So, pag sinabing capacity of observation, may kakayahan siyang unawain kung ano man ang nangyayari sa kanyang paligid. Dapat may sapat siyang kaalaman sa kanyang nakita, narinig, or kanyang naramdaman ng bata sa pangyayari. And next is the capacity to recollection. So, meaning may kakayahan or may kapasidad siyang ma-recall or maalala kung ano man ang kanyang nasaksihan. And next is the kakayahang makipagkomunikasyon or the capacity to communicate. Dapat marunong ang bata na ipahayag ang kanyang nakita sa kaya ng bata na ipaintindi sa iba kung ano man ang kanyang nasaksihan. So, yun yung mga that's the qualification of a child witnesses. What is testimonial knowledge? So, testimonial knowledge refers to the knowledge that a person gain based on the testimony or statements of others. It is a knowledge acquired not through direct experience or personal reasoning, but by trusting that someone else says, writes, or communicates. Generally, there are different types of witnesses. It includes the biased witness, competent witness, dishonest witness, and the instrumental witness, and lastly, the credible witness. So when we say biased witness is, this is a person or a type of witness that has a personal interest in the case, making them likely to exaggerate, distort or suppress the truth. Meaning, bias siya kasi it's either may kakilala siya doon sa kabilang parties, that's why ini-exaggerate or kinukonceal niya kung ano man yung nakita niya. Next is the competent witness. So, pag sinabi natin competent witness, it is a type of witness na fully qualified or those who can really testify with their ability to perceive and communicate facts regardless of their personal beliefs. So, pag sinabi rin natin dishonest witness, para niyang dinidistort or parang pinafabricate na yung nakita niya or nagsasabi siya palagi ng I don't remember para lang para to avoid contradiction. So, pag sinabi rin natin instrumental witness, it attests to the execution of a legal document such as a will, verifies to formality. So, pag sinabing instrument witness, include na dito yung like yung nag-preparma ng will and testament. So, siya pwede siyang gamitin instrumental witness. So, next is the credible witness. So, pag sinabi natin credible witness, it is a reliable and believable but may be disqualified due to mental incapacity, criminal record, or other legal restrictions. And that's the end of my presentation, ma'am, for the summarization of the midterm coverage for the subject, the Clj-5 evidence. I hope that I can answer or I can manage to really learn from what I have said in this presentation. Thank you and God bless.